Hello everyone. In this video, we'll be talking about contempt of court versus freedom of speech. So firstly, let us refresh a bit about what exactly is the concept of contempt of court. Now, if we go by definition, then contempt of court is a concept which seeks to protect the judicial institutions from motivated attacks and unwanted criticisms. So basically, it is a legal mechanism for the courts to punish those who tend to lower its authority. Now, if we were to trace the historical origin of this concept, then this dates back to several centuries in England. So in England, this concept was initially created to protect the judicial power of the king, and later it was transferred to the judges. While with the judges, it ensured their protection and their clear administration of justice, because anyone not obeying the judgment of the judges can be punished by this concept. So it was created for that purpose. Now in India, according to Contempt of Courts Act 1971, contempt can be divided into two types. First is civil contempt. Civil contempt takes place when someone is willfully disobeying a court's order or any undertaking given to the court. Second is criminal contempt. Now, criminal contempt takes place when any person, in his words, written or spoken, signs or actions, tends to scandalize the court, that is, tarnish the image of the court, basically, or tends to interfere or obstruct with the administration of justice. So now we get a basic idea about what exactly is the objective of this concept. So we can part it into three objectives. First is, it is ensuring the status and dignity of the court. So by this contempt of court concept, the dignity of the court is being protected. That is making way for the truthful administration of justice. Then secondly, protecting the judges. That is, it's protecting the judges from any kind of fear or favor while administering justice. And thirdly, it is ensuring public trust. It's preventing the sudden fall of reputation in the eyes of the public. That is what this concept is doing. Now one wonders whether it has a constitutional backing or not. It definitely has a constitutional backing. That is in the form of Article 129 of Indian Constitution, which guarantees or which grants the Supreme Court the power to take action on contempt of itself. There is Article 215, which grants High Court the same power. And then there is Article 142(2), which is granting Supreme Court the power to investigate and punish on the basis of contempt. The context behind this discussion is because recently the Supreme Court of India initiated suo motu proceedings against advocate Prasanth Bhushan for two of his tweets, one against the Chief Justice of India S.A Bobde and some of them against former CJIs. Now Prasanth Bhushan is a lawyer activist and he is known for his works on many legislations, and he is also known as a very outspoken critic of Indian courts. Now this is not the first time that the court is initiating a contempt case against someone. There has been many cases in the past too. Now all this makes us question whether this contempt case or the contempt of courts concept is interfering with the freedom of speech and expression. Now if we discuss on the lines of upholding the freedom of speech and expression, then of course the contempt of court's concept is in conflict with Article 19(1)(a) of Indian Constitution, which recognizes our freedom of speech and expression as a fundamental right. Now, by this, the judiciary is acting in resemblance to the executive. Now, secondly, the definition of contempt is very wide in India, that a contempt case can be taken even with a very small incidents or any kind of mishappenings. So the definition needs to be revised. It is infringing our freedom of speech. Then thirdly, it is liable to be misused, and sometimes this contempt case can complicate simple matters. Next, it can send a wrong signal to the public that the courts cannot tolerate a criticism of themselves. Internationally, many of the democracies like America, England, and Canada have declared this concept as obsolete. That makes us think whether it should be altered or abolished in India. But if we think on the lines of the concept of contempt, then there arises many favorable arguments. They are: this concept is safeguarding the subordinate courts, because without this act, the subordinate courts are losing a remedy to address contempt of themselves. Then secondly, there are a large number of cases piled up in the Supreme Courts and High Courts about contempts, which makes us question its continuing relevance. Now, another argument in favor of this would be that the Contempt of Courts Act is having enough safeguards to prevent its further misuse and to prevent its ability to complicate matters. And lastly, as we know, amending the definition of contempt would lead to lessening the overall impact of the law and also degrade the respect that the judiciary holds in public's eye. Now, analyzing all these points, we come to a conclusion that while contempt of court concept is in conflict with the freedom of speech and expression, it is also standing necessary for us. Now, before moving on to the way ahead, I would like to bring to your notice a particular incident which happened in England, the so-called creator of the concept of contempt. Now, this was in the famous celebrated judgment, the Spycatcher judgment in the 1980s of the House of Lords. Now, in response to it, a British tabloid called the Daily Mirror published an upside-down photos of the Lords and captioned it as "You Old Fools." Now, while responding to it, one of the Lords, Lord Templeton, replied that "I cannot deny that I'm old. It's the truth. Whether I'm a fool or not is the matter of perception of someone else." And saying so, he refused to invoke the powers of contempt on the tabloid. Now, a similar incident happened in 2016 when the Daily Mail published an objectionable content with respect to the judges who were ruling the Brexit judgment. So, what is the way ahead? Based on all the analysis, the merits, demerits, shortcomings, and laws, the concept, there is a need to revisit the need for a law for criminal contempt. And there is also a need to test and create a proper definition for contempt. And the Law Commission had recommended that the case of contempt be restricted only to the civil contempt. Now, in this era of social media, where people are becoming more and more outspoken and they are becoming more and more criticizing, and also where they're expressing their freedom of speech and expression in more amounts than ever, there is definitely a need to revisit this law so that it is compatible with every fundamental right. Thank you.